Everyone is talking about the international global crisis that is presented by Brexit, and we're going to talk about that in a moment. But first, I want to talk about a crisis that not too many people are talking about, and that is the constitutional crisis represented by today's Supreme Court decision on Texas's abortion law. Now, we had a op-ed on Slate via the Drudge Report, and this particular law professor is talking about what many people term a living constitution. Let me lay this out for you, and then we'll review what the Supreme Court decision does and why a living constitution is so dangerous. He says, I see absolutely no value to a judge spending decades, years, months, weeks, days, hours, minutes, or even seconds, no seconds, studying the Constitution, the history of its enactment, its amendments, its implementation across the centuries. He says it means that the original Constitution, the Bill of Rights, and the post-Civil War amendments do not speak to us today. Why? Because no matter how smart these guys were, these dead white men living in the 18th century, they don't know about our culture, our technology, things in the 21st century. The problem is human nature doesn't change. Human nature has stayed the same throughout all of history. The Constitution was written to control human nature, not to control technologies. It is bigger than the technologies that we have. It's about principles. It's about the rule of law. Because what he goes on to say is the Supreme Court should treat the Constitution like it's authorizing the court to create a common law of constitutional law based on current concerns, not on what those 18th century guys are worrying about. Understand this. What they are doing is creating a body of law that is independent, not accountable to the written law. You see, we have a written law because we didn't want to let political appointees or a king or anyone else dictate to us what our laws would be without any kind of representation. We fought a war because we didn't want taxation without representation, yet we have not only taxation, but legislation without representation. This is what's so dangerous about this. It is a in-your-face dictatorship by the judges, by our executive branch, by Obama. That is what's happening now. We no longer have a rule of law. Now, these judges swear to uphold the Constitution, don't they? But they shouldn't spend any time, not even a second, not hours, minutes, or even seconds, studying what they swear to uphold, because they are under the Constitution. They are merely temporary stewards of the Constitution. These are principles. We have a process for amending it. We have a process for writing laws, but they don't care about our elected legislature. We have people who want to rule by executive order, by fiat, and that's what these judges are doing today. You see, we also have a secret court, a FISA court, and they are also creating a body of law that they say has the same effect as the Constitution, and yet we're not even allowed to see what that secretive body of law is. That's what should concern us. We have a dictatorship. We have a secret dictatorship, except now they're publicly saying, we want a living Constitution, one that actually has absolutely nothing to do with that written piece of paper that we all swear allegiance to. Now, this is what happened, and I pointed this out earlier today on the fourth hour of the radio show. We had 5 justices. We had a justice that was appointed by Ronald Reagan joining with the Clinton justices, joining with the Obama justices to support abortion, not to act as impartial referees of a law that is created by someone else, because we had a division of powers. These are principles, eternal principles based upon human nature and the understanding that power corrupts. Absolute power corrupts absolutely, and power wants to concentrate itself in Washington. That's why we have the Constitution that divides power. But look at what they did. This is a situation where these justices came in, and as Justice Alito pointed out in his dissent, and as the Wall Street Journal pointed out, he was visibly disturbed, visibly angry, rocking back and forth in his seat as he listened to this other decision. What they said in the decision was they basically laid out the number of clinics had been cut in half by these rules. They said, look at how far people have to go to get an abortion, for example. So it was a pragmatic examination of the consequences of this law. It had absolutely nothing to do with the law itself. As a matter of fact, what this decision did was to shut down the Supreme Court's own decisions and the principle of law that has long been held that you don't get a do-over. As Justice Alito pointed out, they had already adjudicated this in a court, they had lost, they had failed to appeal, and now they came back with exactly the same case, the same law, and took it to the Supreme Court. He said it should never have been heard. Furthermore, he said they violated a second fundamental principle of law, and that is severability. It was made abundantly clear throughout the Texas law that all of these different regulations that were put on, some of them said that you had to have someone who was admitted to a nearby hospital to be present there as part of the abortion clinic. You could strike down something like that, but they even struck down fire regulations. And he said all of these regulations were independent of each other, but they took out everything. And it was made clear in the law that they were all severable. In other words, these were independent legislation issues, some of them having to do with safety. And so when you look at this and you say, well, all they did was look at the current society and say, well, we would like to have abortion easily available, and we don't really care what the principles of the Constitution are. We don't care what historically the principles of law have been, so we're just going to fine for that. And how does this work itself out in other ways? I would say to many of the people who are looking at this, look at the story from The Intercept. When they talk about a right to privacy for abortion, think about this right to privacy. We've got the FBI and the police are knocking on activists' doors ahead of the Republican National Convention to intimidate people. And you got the head of the NAACP saying the purpose of these door knocks is simple: to intimidate the target and others in efforts to discourage people from engaging in lawful First Amendment activities. Now, we just talked to Roger Stone the end of last week. He talked about how they have shrunk the area that they had as a security area from a 4-mile radius down to a 1-mile radius. They want to contain demonstrators in a very small area, essentially, well, literally box them in and have them all together, people who are on different sides of the issue, trying to create conflict, but also to stifle and to suppress our First Amendment rights, to intimidate people. Where is the right to privacy when we go to the airport? Where's the right to privacy from the surveillance state? Nowhere. The Supreme Court is no friend to the right to privacy. And yet they will strike down all of these laws and give a do-over to these people, violating all the rules, procedures, and the Constitution in order to further their agenda. This is not judicial activism. This is simply a dictatorship. Simply a dictatorship. And we can see that when we look at the other aspects where this is coming out.